I did not find any need for correction. Let's turn it over to counsel. Mr. Ringstrom, any corrections or objections to make to the contents of that report?
No, Your Honor.
Mr. Hartel?
No, Your Honor.
All right, we're going to turn to allocution in just a moment, but I want to make sure I state on the record that prior to the date, the court has received from the from the defense attorney here, a couple things. The first one is a Catholic Human Services substance use assessment that was dated February 13th of this year. I did review it. I did review it in its entirety. In fact, I made notes here. Also, I received, and this was probably just last Thursday, a mitigation report prepared by the public defender's office through their social worker, Mr. Heiniger, Heyniger. And I reviewed that in its entirety and made notes on it as well. Mr. Rickstrom, any allocution, sir?
Your Honor, I have received all those documents as well. I've gone over them. Interesting enough, especially with the Catholic Human Services report, he reported to them that he does not have a current problem with alcohol, but he's sitting here with a problem from alcohol because he's sitting here facing sentencing for his 9th drinking and driving.
And before you go over any further from there, I'm gonna let you turn back. On page 3 of 5 in that report, it showed that his alcohol use disorder was mild, but it did say minimization of use cannot be ruled out. Also, on page 1, underneath the legal status, it says he had 2 prior drinking and driving, and this is actually his 9th.
This is the actual 9th.
And there's one more thing here that I don't know if anybody paid attention to. On page 2 of 5 in the Catholic Human Services report, it said he had not used marijuana since 2000. But if you compare that to the PSI information provided through the defense, it was 2006. So when I look at these two things, there are several misinformation. But go ahead, Mr.
Yes, Your Honor. These Catholic Human Services reports usually tend to just write down whatever they say. I wish they were a whole lot more effective than what they are at this point in time. That being said, the sensitive information report, I believe, is really effective. At first, I was thinking it was 10 OWIs. I did read number 11 of 19. It turned out that although he was charged with an OWI second, apparently it didn't get that way. So it was only 9, but here we are. He didn't learn his lesson the first 8 times, and we're here again with this. And he's trying to say that he doesn't have an alcohol problem. Well, I agree with the recommendation fully, Your Honor. I think that he does need to sit more time in jail. I think that he does need to have a longer stint of probation. They suggested 3 years. I'd even be willing to go 5, but 3 years is fine at this point in time. And he needs a lot of services, and he needs to learn that he just can't drink at all or do any other drugs at this point too.
Mr. Hartel?
Yes, thank you, Your Honor. I'd ask the court to factor in that it has been over a decade since my client got arrested. He does have family for moral support, well, at least for the OWIs, if I recall correctly. He does have quite a bit of moral support behind me in the courtroom, including back along the wall. I made sure to confirm that they all still support him. Sometimes family goes sideways on that, but not this family. I asked the court to factor that in. He does unfortunately not qualify for the 10-year rule as far as when he got off probation.
I saw that there was that 10-year, almost got the 10-year gap.
Very close, Your Honor.
Very
In
close.
fact, I believe he would have scored significantly lower with an inference of no jail. If the 10-year rule had applied, we realized that it's not there, but we asked the court to factor that in. If I recall correctly, that was far enough back that the probation department didn't offer getting off early at the halfway point. I believe he most likely would have if it had been allowed, because if I recall correctly, he had paid off his fines early, and perhaps his reporting duties were a little bit less than they would otherwise be, but still technically people weren't getting off at the halfway point. I just asked the court to factor that in when fashioning a sentence, since, as the court often reminds us, sentencing guidelines are not mandatory. This is one of the few situations, I believe, well, I shouldn't say a few, it's one of the situations I believe where it would be appropriate to go below guidelines, because it has been more than that 10 years since the OWI in the past. Yes, he had several of them. Yes, that's an issue, but what I believe my client means when he says he doesn't have a current problem with drinking isn't that he didn't have a slip. He obviously did, or he wouldn't be here. But he doesn't feel that he can't go a day without drinking, without having the shakes, the huge withdrawals. There's a difference between doing things that you shouldn't do and being the extremes. And I believe that's what he was meaning when he was talking to Catholic Human Services. I just asked the court to factor in. I don't believe he was trying to pull the rug out on anyone, pull the wool over anyone's eyes. Might be mixing up my analogies there a bit. But I do believe that he has every intent to obey the law. I know that I was sitting in the court a minute ago when the court did grant a longer probation for, albeit a younger gentleman, but I believe that would be appropriate in this situation as well. I believe my client sat an appropriate amount of jail time when we factor in everything. I do believe it would be appropriate to release him even today with perhaps even more probation than we normally would. Give him that little bit of extra rope. He does have the family there for moral support. And if he even sneezed wrong, the court could tug on that. I do believe that would be the appropriate way to do this. Thank you.
All right, sir. Mr. Sarrazin, is there anything you wish to say?
No, sir.
I've got a question. In this report, if the attorneys want to follow along, they can. CFJ 284, page 2, the second to last paragraph from the bottom. Whose vehicle were you driving?
It was my wife's. Mindy Sarrazin.
All right. I thought you were going to your girlfriend's house.
Pardon?
Weren't you going to a girlfriend's home?
I was going to a Super Bowl party.
All right. So here's the two paragraphs above that in the same page. The defendant advised he was coming from the Lake City Eagles and was en route to his girlfriend's home on Arnold Road.
Yeah, I had a girlfriend there.
Okay. Were you married at the same time?
We were separated.
Okay. And so your wife had this car and it had no registration, no insurance. Is that right?
Yeah.
Okay. How do you have, were you living with your wife at the time that you had access to this car?
Yeah.
Okay. Well, see, now there's a reason why I think this is important. Now, by the way, I see some head shakes in the back now going left to right instead of up and down. So here's where I'm getting at. How good is that support and then, by the way, folks, I'm not saying it's true. I'm just taking the words in the piece of paper that everybody told me I could consider as the truth because they had no challenges here. If I had a wife in the back, is the wife back here?
Oh, I'm here.
All right. So let me just say this. I'm not going to ask any further questions. If I were to ask the wife, do you give him your car? I would look and then say to Mr. Hartel, the quality of that support is 0. Because that, I'm not saying you did this. Pay attention, please. There's a method to the reasoning. I would say they are the ones enabling him if they are giving him their car. I'm not saying that happened, man. I'm just saying, without bringing somebody up here to ask them further questions, I'm going to tell you, whenever I see somebody who's got 9 drinking and drivings, and then I look and see that he doesn't have, he has a car, that has no insurance, no registration, I would look and say, well, you're to blame. You shouldn't give the guy a car because he cannot drive a car. It's against the law. So, no. He just told me a moment ago you're going to a Super Bowl game, but yet here you told the police you're going to your girlfriend's house. I think you got bigger problems than this, what I'm talking about today. So, also, you lied to the police officers when they asked you you've been drinking. You said no. Even though other drivers called you in and said, hey, look out for this guy. And they found you in the ditch. If you end up in the ditch with a car, and then the police officers ask, were you drinking? And you say no, it's just kind of funny and sad. So you were driving without a license, you're driving without insurance, you're driving an unregistered car, and you should never have been driving a car in the first place, and you knew it. So Mr. Hartel's argument is that, well, he only may drink a couple times a week, but he doesn't eat it every day. Means that when you do decide to drink, you're going to drink and get a 0.14 and drive a car and do it recklessly and potentially injure people, because you could have been injured in this accident. So, no. And again, when the defense puts together these facts, I really greatly appreciate the public defenders program and having social workers there to help. Make sure you do a better job and you can compare what your person provides and what Catholic Human provides, because it tells me that every time I read these, I read them with a fine-tooth comb. And when you give me two forms that don't compare well, and one of them, it's prepared from somebody outside of the public defender's office, differs, you lose credibility. So it's not the public defender's fault, because Mr. Heiniger, he may have been he gave his information probably based on speaking with you, because it was before the PSI was, well, actually maybe right around the same time. But also Catholic Human Services, I give them more credit because because they don't have any dog in the fight. And so therefore, I assume what they tell me was the truth, or at least based upon what you provided. And the information you provided them is inconsistent with the other proof in the pre-sentence investigation report. You should never, ever, ever drive a car. You should never, ever consume alcohol. You know it. That's why you lied. You know it. That's why you drove somebody else's vehicle. So let's look over your criminal history. It began in 1972 with a larceny. Not that big of a case, but okay. You got probation, but you violated probation. And within 1 month, you picked up new charges. And you got another property crime as a breaking and entering. There, looks like you made it about a year and a couple months until 1975. And this was just a marijuana case. But again, you violated probation. Then you made it 1 month after being off of probation and after your jail service before you picked up your fourth case. That was a receiving and concealing stolen property and breaking and entering, more property crimes and crimes of dishonesty. And then you made it 2 years until you picked up your first driving under the influence in 1978. You then made it about 5 years until 1985 after you got off of probation, and you got a use of marijuana. Again, I know that we look at marijuana differently today, but it's still concerning. Looks like about 2 weeks after being on bond for that marijuana charge, you got drinking and driving number 2. You then made it 2.5 years. Then you picked up marijuana case number 2. That's right. Oh, well, that's actually marijuana case number 3. Then you made it until 1989. You were on bond for about 2 weeks for that one. I'm sorry. And then you picked up the receiving and no, take that back. Go back and say that more correctly. In 1989, you picked up marijuana case number 3. While you were on bond for that, you made it exactly 2 weeks before you picked up your next case, which was your third drinking and driving. You violated probation within 7 months, and your probation was revoked. 1 year later, you picked up drinking and driving number 4 in 1990. You had violated probation again, so I already see that probation doesn't work. And you made it 8 months later before picking up another case. This one here was, you got charged as an operating while intoxicated, and they gave you a open intox. Still, that's a driving with alcohol. That's an issue. It's not the same thing as a drinking and driving. That surprised me, but that was here in Missaukee County back in 1994. You made it 5 months. Oh, by the way, driving license suspended, which means you're going to do whatever you want because you're going to justify your own actions. So you made it 5 months later after that case. You picked up drinking and driving number 5. After you got off of probation there, you made it 5 months until 1999. Then you get an act of domestic violence. You made it 15 months after that before picking up drinking and driving number 6. And then between 2003, when you were off of probation for that number 6 drinking and driving, you made it 5 weeks. Drinking and driving number 7. Went to prison. So far I know jail doesn't work, fines and costs don't work, probation doesn't work, bond doesn't work, and here, in that case, the one you went to prison, you absconded on bond. All right, but while that case was pending, you picked up that absconding file. Then 6 weeks later, you picked up another case, but that was dismissed, so I discount that. And here's where you almost had your 10-year gap. Had you not absconded on bond, you would have had a 10-year gap, which means everything I've talked about wouldn't have been used on your score to the guidelines. But you shot yourself in the foot. 2014 comes along and drinking and driving number 8 comes up. And now here we are. Again, you were really close to another 10-year gap, but you pick up number 9. That tells me you're starting to figure out how to be a person who will do what he wants. You've got a severe alcohol problem. And you put people, including yourself, at risk. You get other people to turn and look the other way. You know you can't drive. You know you can't. You're driving a car illegally, and you don't care. So everyone else out there is wrong. You told me that bond doesn't work, probation doesn't work, jail doesn't work, prison doesn't work. You told me you're going to drive a car anytime you want. The fact that you didn't get caught for a period of time, that means you're just really good at being not getting caught. So, no, I disagree with the probation department. I disagree with the prosecutor. I disagree with Mr. Hartel. Based upon everything I've said, a reasonable and proportionate sentence that is also within the guidelines is exactly what I'm going to give. $68 state minimum fee, $130 crime victims' right fund fee. I'm not going to add any court cost. I must add the minimum $500 fine. I'm not going to give any attorney fee because I also know you've got a $20,000 restitution bill out there. All right? Yeah. You owe $20,000 from a 2006 case. If you can afford to go out there and boozing and drinking and stuff like that, you sure as heck can pay more than $25 a month. You're bad choices and you can't even take care of your own responsibilities. It's only because of that I'm not adding other fines and costs, but it's not going to matter because your likelihood of being able to pay it is going to go way down. There is no supervision fee because there is no probation. This court chooses and elects to sentence the defendant just as he pled. it's funny to me when everybody pleads to a habitual offender enhancement, and then they tell me, we don't really want him to get the impact of the enhancement, therefore give him to jail. No, court sentences the defendant to a prison term of 24 to 90 months. The court awards the defendant the required period of credit, which is 57 days. Based upon everything I have said, not only is that within the guidelines, it is definitely reasonable and proportionate based upon his history and everything else I've covered. So, Mr. Sarrazin, I'm very sorry, but I don't, part of me is sorry. Most of me isn't. Because you asked for it. You knew it. You knew all of this. You knew every step of this was a risk. And that's it. All right, Mr. Hartel is going to bring you 2 copies of one document. You're going to place your initials on one, and you're going to take the other one with you. Linda, I only have 1 copy of the,
I'll give him another one for the jail.
all right, thank you. Here you go, Mr. Hartel. You have the right to appeal the conviction and sentence in your case. That is typically done by filing a claim of right to appeal. However, based upon the plea in this case, any appeal is done by filing an application for leave to appeal. If you choose to file an application for leave to appeal and you want the court to appoint an attorney to assist you, you may complete the bottom half of the copy of the document and return to the court within 42 days. If you choose not to appeal, you may dispose of your copy of the document. Again, this is within, my sentence is within the guidelines. Therefore, it was considered by the parties at the time they entered the agreement. And I've covered an extensive fact pattern and history here. You're lucky that the car wasn't titled in your name, because it would then be immobilized. No one would touch that car. It would just sit there for 3 years. But wasn't in his name. All right, that's the sentence. Mr. Blazak, have I missed anything?
Don't believe so, Your Honor. Thank you.
Mr. Ringstrom
No, Your Honor.
and Mr. Hartel, you got that 1 page signed, and Madam Clerk's going to get the extra copy for him. Thank you very much. All right.
I'll get it to him over at the jail.
It'll be brought over to you there in the jail. Thank you very much. We are excused or adjourned.